Good morning. Our topic today really is for two purposes, and we're going to talk about visuals and using visuals in making presentations. And I know that my audience for this tape is really a group of faculty members, and again, I want to really thank you for giving your time to our efforts to teach the Emory students about how to use visuals in making presentations. And I know that obviously part of the audience may be also students in this case, and we're going to the topic is, in the Emory Trial Techniques program, is the one that has the most broad application. Obviously, there are many times when you're going to make presentations, whether it's to a client, where you're going to do a presentation that's called a beauty contest, where you're trying to draw the client to choose you as a lawyer. You may be making a presentation to teach in a community setting of some sort. And so I want to make sure that our topic is seen as being broad enough. It's a topic about the use of visuals. Let me also talk to the faculty out there in particular, those of you that are not at all sure that it really is wise to use technology in particular as a way of displaying various ideas in a courtroom. And tell you that and encourage you to realize that part of our resistance, my resistance frankly, where I start out on this topic, is to say I'm not sure it's needed, it seems to be too slick, I'm nervous about the technology, and so I'm not sure it's a great idea to use it. I don't know how to compete with it. And frankly, part of the social science research is that we resist it because many of us have really been rewarded for our learning style, our particular learning style. And typically, the more educated the audience, the more that the audience is used to getting information through their ears. Now, having said that, recognizing that because we may, in fact, learn that way and learn well that way, that in fact, many folks out there, even many very highly educated folks, need visuals to help them learn, and in fact, are greatly assisted by those visuals. And would like to talk to you then about, if you choose with your particular audience to use visuals to help present your ideas and materials, that you think about how to be most effective. Ed Tufte, who is one of the masters, if you ever see his name about giving presentations and using visuals to persuade, from Yale, he is a marvelous speaker and presenter, would say that PowerPoint in particular, he worries about the way that it's being used. One of the things that we learn about people using PowerPoint is that it can be used very ineffectively. It can be one, frankly, PowerPoint slide after another. And have you ever been in an audience where somebody's using PowerPoint? They're using it so quickly, and it seems to be in some ways repeating or giving a really quick preview of where they're going, that what happens is you don't know whether to listen to them or to look at the screen. And because you're divided between those two, frankly, you check out. So what I'd like to do is I'd like to use some visuals to make a presentation to you. And while I'm using them, I hope I can show you both things that work and things that don't work, and point out those things to you as a way of getting us all to think how to use visuals in a way that's most persuasive. Now, first of all, let me just point out a little thing here. I don't know if you can pick this up on the screen, but there's a little white dot, and those of you that have seen me use PowerPoint before know that I like a black screen. I like a black screen to start, and I like this little white dot that tells me that the PowerPoint is ready, the visuals are ready, because otherwise I have this moment of panic. Did it crash on me? And I also know that if I start with it already up, that frankly, most of the social science research tells us that I can't compete. That once there's something on the screen, it's very hard for you to listen to me. Instead, your eyes are drawn to that screen, wondering about it, asking about it. And so I like to start every one of my presentations with a black screen and tell you that what I like to do if I'm operating it myself is to be able to have that as the first screen, so that if I need to take down the visuals, I can hit 1 and enter, and then I go to black screen and I'm off and running. And it's very important to be able to go to a black screen. And in fact, most remote clickers today provide you with a little rough spot right at the bottom, and the rough spot right at the bottom is your blackout. It allows you to take back the center, what the theater people call the spotlight, so that everybody can focus on what it is that you have to say. So our first point in our discussion is to say that because you use visuals, don't become captured by them and feel trapped by them, so that you feel like once you're in the visuals, you're stuck in them for every purpose. Now, we'll talk more about this as we go along, but another thing is that whatever your software you're using to display the visuals, again, learn about how to navigate with that software. So, for example, if you're using PowerPoint, know that you can navigate the software simply by typing in a different set of numbers and hitting enter to get to wherever it is that you want to go. So if you want to, in the State versus Mitchell, go to a slide about a picture that lays out the way that the body falls, you note on your notes what the slide number is for that slide. And as long as you know what the number is, you type the number in and you're ready to go. And so we provide, and we recommend that if you're using PowerPoint, that you have a set of thumbnails with numbers of the slides. And that allows you to navigate around to whatever the slide is that you need. Now, of course, if you forget the slide number, well, you can go into, as you know, slide view mode, and go into the slide view mode and find the number of the slide and then go ahead and pull that particular slide up. It's not a panic situation. If you can't remember what the slide number is, you can still find it. It's a little less slick, but you know, especially with jurors, they know what you're doing. In fact, in early days when we would use PowerPoint in the courtroom or in a presentation, we would ask our audiences what they thought about it. And if we asked them how many people have seen PowerPoint presentations, it is virtually unanimous that everybody has seen it. And most people talk about how their kids have prepared it as part of school work and homework. So I want to recognize that, in fact, the notion that people are put off by it, they're not familiar with it, is really, I think, a thing of the past. And that in addition, television has taught us that any presentation that's worth something is going to be supplemented by showing us documents, helping us see what the things say, giving us little pictures as CNN does of the person who's talking, and then the quotes that help us read and understand what the person has to say. And so the visuals become an assist to the learning. So we don't just have to pick up the information through our ears. Now let me break out some of the things that I'm going to say into really two basic parts. One is I hope to spend a little time and tell you what is going on in the courtroom in terms of the way that technology is being used and visuals are being used. Then after I go and show you some of those things, then what I like to do is to show you how you can use it and use it effectively. And so my bridge is going to be from what's going on in the courtroom. I hope to give you some incentives to use it in the courtroom, but also then to give you some general tips about how to use it effectively that you can use and import into a variety of settings, whether it is in a courtroom setting or a variety of settings. So let's talk about it. You know, just as a few years ago, as 10 years ago, there was this technology in the courtroom. And I can tell you that if you went to the U.S. Attorney's Training School in Columbia, South Carolina, you would spend a good deal of time with this piece of equipment. It is an evidence camera. And as an evidence camera, most courtrooms today have evidence cameras. All it is very simply, is that this is a camera, and what it does is it takes a picture of what's underneath it and it projects it up on a screen. Now the beauty of the evidence camera is that it is your backup if you're using some more high-tech methods. The evidence camera, if your system crashes or you can't find it, you can go to the hard copy of whatever is the exhibit and put that hard copy under the evidence camera and project it up on the screen. So you're going to hear this all the time. Well, if you're going to use technology to display your visuals, you want to always have a backup. And frankly, in very high-tech settings, maybe you want to have a separate computer backup system. But just want to recognize for you that if you haven't prepared a backup, a specific backup, a technology backup, that one of the backups is sitting right next to you very often on counsel table, and it's an evidence camera. Now, I want to start here also because I want to tell you about what are some tips for effective uses of evidence cameras. The thing about evidence cameras that's particularly good is that you'll see there are a set of buttons that are down here down the side. And if you're working in one of the classrooms that has an evidence camera, go up and take a look at it. Put your fingers on it. Turn it on. See that it has basically along here to the right 2 basic buttons that are really all you need to know. One is that it takes a big picture, and the other is that it's got a zoom button, and you push the zoom button and it zooms on into what you have to say. Now, in that very simple 2-button process are the heart of all I have to say to you about the use of visuals. When you put up an exhibit, the first thing that you need to do is to let your audience take in the overall and big picture of it. That if you zoom too quickly, you lose the context of what it is that's being said. And so, remember when you worked on exhibits in earlier weeks, we talked about first having the witness look at the exhibit and say, here's what it is, here's what it describes. Let me take you into the overall setting of the exhibit before I point out specifically what it is that I want you to see, where the bullet was found or whatever we're talking about. And the evidence camera, when you put a sheet underneath it, allows you to start with the big picture of it and then zoom in. Now, the evidence camera in particular is great for small things because what it allows you to do, the jury to do, is to discover for themselves as you zoom into the small things what you want them to discover. Imagine it's a bullet. Imagine that the bullet has rings that help an expert identify that this bullet comes from a particular gun that's the defendant's gun. And you put the bullet underneath it and you show it. Or you've got an identification mark on a ring that gives us an idea that it belongs to somebody. The evidence camera is terrific. It's sharp, it's clear, and it'll draw you down into it, and it helps you as a viewer discover for yourself the import of it. All right, now in a number of years that followed the evidence camera and the presentation of the evidence camera, you had what are these old clunky, remember the looks of these computer screens, these old clunky boxes. And this is actually a picture of the Oregon court. The Oregon court, state of Oregon, required that they go paperless in all of its cases. And so they filled their courtrooms with these great big clunky boxes in order to be able to have a screen at virtually every place you might want to see. So you can see that you've got boxes on the tables, you've got boxes here in the middle, you've got boxes up by the witness stand, and there's a box up for the judge. And a big box, a television screen for the presentation of the information. Well, Oregon's experiment, I have to tell you, was mixed. The problem is that when folks come into these courtrooms, the lawyers in particular became intimidated very often and didn't use it. And so Oregon put everybody through an elaborate training program. Some courts were more successful than others in doing this. But I have to tell you, it was a mixed result in trying to go paperless. I can tell you that for many people on the court, the great advantage of the visual displays was that it shortened the trial time. By most estimates, the Oregon court suggested that it shortened the time by 50%. And let me just give you one place where enormous time was spent. If you, in the old system, wanted to give to a jury a document, well, you would either have to make 12 individual copies for the jury, or you would hand the copy to an individual jury, and the judge would instruct them, please look at it and pass it on from person to person until everybody has seen it. Well, you can imagine how slow that might be. And you could imagine that the court might, in fact, want to try to find out ways to speed that up. And of course, if you've got a large enough screen for everybody to see the exhibit, well, then that's taken care of quite easily. And similarly, when you give up the exhibit, the problem is, what are they looking at? And how do I control what they're looking at? And again, a visual, especially a visual that's technology displayed, can allow you to look carefully at what you want them to look at by call-outs and zoom-in features. So here's the old day. Very quickly we move to the modern day, and let me just tell you that every federal district court in the United States that's being renovated is being renovated somewhat like this court in Orlando, Florida. So now we've got flat panel screens every place. Still got a computer box up there where we might get some other different kinds of information. But you can see that what we've got is we've flattened it down and made it more high-tech. Now, if you didn't want to show things per screen and you wanted to project them up into a screen for everybody to see, basically you've got what you need if you've got a projector and if you've got a computer and you've got a cable that connects the two. Courts used to resist this all the time because they were afraid you had to turn off the lights in order to be able to use projectors. The lumens of projectors now have become so much better that the problem of turning off the lights, assuming that you use good color combinations, is really diminished dramatically. And so the idea is that with these high definition cameras, you can project up on big screens very good detail, documents, and specific information. Now you need to know that most courts today have also set up a situation for witnesses to be able to interact with the screen and be able to highlight and use the John Madden pen and be able to show us things right on the screen in order to be able to do what we need to do. Now when you do that, of course, in a courtroom, it creates a capture problem. In other presentations, you don't have to worry about that. And you know, you've got wonderful tablets today, PC tablets, that allow you to go ahead and annotate right as you talk and show things and color things and highlight them. So, when you come into a federal court that's been renovated, you see something like this. You see something like what we have here in the courtroom, which is a control panel place for video, to show tapes, CDs. You've got the evidence camera, you can see, that's on the right as your backup. And you've got a computer that sits into this evidence place, and the computer can allow you to then display whatever is on your computer, both for yourself to see and out to the various places around the courtroom. Now I want to stop here and also talk about technology generally, not just visuals, but technology generally. Technology generally has opened up some wonderful issues for us, in that in a courtroom setting, if we can do remote conferencing, we could bring witnesses into the courtroom, even though they're not in the courtroom. What does that do to confrontation questions? What does that do for our ability to interview child witnesses? How about importing experts who may be outside the jurisdiction or hundreds of miles away? What about fact witnesses who can appear and could be cross-examined? The questions that it raises are really quite interesting. We might be able to, in fact, have a virtual trial. You can see this is from the Orlando courtroom, where what we have is an expert witness who's testifying. We can see a picture of the person who's questioning him on site here in this small box along the screen. And the expert is presenting his own visuals to the jury back here for them to look at and examine for themselves. And so presentations presumably could evolve into a virtual trial. In fact, some people dream of, what do you call those multi-camera projections of an individual, so that instead of the flat screen box, we would have this expert appear in this kind of camera projection way, sitting in there, and it would just substitute for live. Because the remote audio is getting so much better, we don't have the problems of delay, and it creates some really interesting questions for us for the way that technology could assist in providing information, and how technology, in a sense, could substitute for live presentations. One last point here I can't resist, and that is to say that remote arraignments are also being discussed. We all know the Nichols situation. Could you take care of the danger situation by having a remote arraignment? What does that do to the confrontation rights? What does that do to making sure that the judge ensures that the witness or the accused understands their rights, their constitutional rights? But arraignments remote are also a possibility that are created by technology in the courtroom. So, as a real quick review of what is going on, what you'll face in most federal courtrooms today, certainly the ones that have been renovated, is like this Courtroom 23 in Orlando. You've got your center podium. You've got a witness stand that allows a witness to annotate what's going on. You've got flat screen projections for the jurors to see. And you've got counsel table. And very often what you have is a master control switch by a court. So the court has the ability to take everything down right away to make sure that there is no prejudice to the jury. And that's also one of the features of one of these multi-position display systems that you are going to confront. So if you walk into an Orlando courtroom, Courtroom 23, don't be surprised. And in fact, as you put your case together, start to plan how visuals are going to assist your presentation. Now, if you are like me and you like the sound of your own voice, frankly, and you are enamored by it, it may be that you say, oh, I'm not going to use any of that stuff. I've been doing just fine without it. I have to tell you, that's my original skepticism about visuals and the use of visuals to teach. But let me take you through, and some of you who've been in my torts class have seen this before, but let me tell you where it is that it seems to me I discovered, ooh, this visual stuff is more powerful than I was giving them credit for. And so let me very briefly tell you a war story about my involvement in a case, and the case was this case. Well, let me just bump over the top of this. And I'm sorry I'm not using this appropriately because my plan was to have you realize with me a set of truths that oral alone rarely beats oral plus visuals, that harder facts need more careful visuals, that poorly directed visuals contribute less, and that visuals without a case theory don't work, and give you all those cautions to what it is that I'm saying. But I think I can also demonstrate that by, in fact, showing you this war story. So, imagine that what you have is a case, you're representing the plaintiff, and the case involves a 12-year-old boy. Now, the 12-year-old boy is up in the third floor of an apartment complex across the street from a power station, that's one way to describe it, that has transformers on it. And there is a light that is up in the corner. And as he's sitting that night in his bed, his 3-year-old sister comes in and grabs on him and cries and complains and says she can't sleep because the light is keeping her awake. Now, as a great 12-year-old brother, what he does is he decides to do a little investigation, and so he leaves his third-floor apartment and he goes downstairs and he climbs into this transformer to try to unscrew the light bulb. And when he climbs into it, he becomes badly burned. Now, you could see that where he became burned was when he got caught into the bushings and the regulator that were on a platform where there was a ground wire and a street. There were control boxes down here, and there was a ladder-like lattice where we're told that he climbed up into the power station. Now, in making a presentation about this case, then, this one visual gives us a sense of what it is that we're dealing with. And it makes it clear, presumably, and efficient for us to understand. As the plaintiff is presenting its case, the plaintiff is saying, look, the way that NESC, who owned that power station, how were they supposed to operate it? And in fact, came up with a standard that it had internally to it about how it was supposed to operate a power station like this that's out there in the public, providing that electricity to the folks in the community. And it was not supposed to be readily climbable. So plaintiff presents then a review of the way that this power station is structured and looks at it concerning its low clearance to the ground, finds that the loose ground wire gives somebody something to hang on to be able to pull themselves up, that the ladder-like lattice is a place where, with a little bit of energy, you could get your foot up and pull yourself up on. So the problems the plaintiff presents are these. First, the problems are that it was too low to the ground, it was readily climbable in a variety of ways, there was no warning sign and no fence. And so the cures, say the plaintiff, are raise the platform, staple the ground wire, post warning signs, or build a fence. You can see from this animation that what we've got is really a very clear and quick understanding of how it is that the plaintiff says that this power station is negligently maintained. We've got the standard, and in about 2 minutes, 3 minutes time, you know what the plaintiff's theory is about the case. Now look here at what the plaintiff then does. The plaintiff then turns and says, I've got a problem, and I want to try to argue to the jury that the plaintiff, while contributory negligent, after all, a 12-year-old boy, his negligence, certainly motivated by a concern for his sister, should not eat up all the liability. Look at this then and tell me what you see. This chart is to ask you about whether or not NESC, the owner of the power station, has a higher duty. And so, let's look at what the NESC knew first. It violated industry rules by the way that it constructed its power station. Second, it violated company standards. Remember, we saw their own internal standard about whether it's supposed to be readily climbable. It was interesting, the power station was built about when the plaintiff was born, our 12-year-old boy was born. And they had, that whole time, they had the ability to build a fence. They had an ability to repair it. They had that kind of time. And they had that kind of time with knowledge of the danger of the power station. And also, they had knowledge about the power station, and it was better than anybody else in the community. It was, therefore, more of a duty for them because they knew the danger better than other folks did. And they knew the magnitude of the risk. They knew about the level of burns that could be created by high voltage power coming in that station. So compare. Compare, members of the jury, NESC's knowledge with a single impulsive act of a 12-year-old. Now, what do you see? You see the height. Compare the height. You see yellow on red as opposed to a blue background. What do you see? The height of the blue box in relationship to the height. Now, I'm pointing these things out. They were not pointed out to the focus groups and jurors that saw this. But you know that in just about every focus group, the overwhelming comparison of liability was 75-25, which turns out to be almost exactly the relative height of those two boxes. 75-25. Now, you know, when we first saw this, we really experimented with making this box lower. We thought, well, okay, if we can produce that kind of visual effect, what we need to do is to shrink it down. Maybe we can make it 10% if we can make it smaller. But you know, frankly, and that's why I would argue to you, visuals can't win cases where the facts are not there. Visuals can help you and assist you if you've got a good, tight theory. And here is where the normative issue really comes in. You have to still ask yourself, what is that fair amount? What is that credible amount? What is that amount that if I put it too small, the other side gets up and laughs at me and points out how ridiculously small that is in the light of what it is that we know 12-year-old boys know. But if I present it fairly, it grabs you. Hopefully, it grabs the truth of what it is that you have to say. And of course, the power of the visual is that in one screen now, we have what would otherwise be quite a complex thing to explain, which is the relative and comparative negligence, and why you say as a plaintiff that in fact, while it should be granted some weight, it should not nearly come to a 50-50 weight. So if that persuades you, it certainly persuades me that this visual assists in the communication of the theory, then our understanding about how visuals can assist, how they can supplement what it is that you have to say, is something that we've got to keep an eye on in our persuasion. Many of you see an inconvenient truth. Many of you see the marvelous bit of advocacy that's done by Gore. What does he do? He gets in that loader and he goes up and he shows you how much higher the temperature, the average temperature is going to be and what it's going to cause in the way of global warming. And he has a graph, and we all know that the graph and the scale of the graph is crucial to the persuasion, but he visualizes it for us. And we see that in fact the earth is getting warmer. And the visual persuades. It helps carry the message. All right? If you're with me, as the Brits would say, about whether or not visuals persuade or assist in the persuasion, let's think together about then what you might do in a presentation. Now, you know, the setting we've got is to ask you to make a presentation to a prosecutor to advise the prosecutor about what the range of negotiation authority they want to give to the individual prosecutor. Should you settle this case with Joe Mitchell? Second-degree murder, okay? How about manslaughter? Is that going to be sufficient? Or do you need first-degree murder? Well, busy chief prosecutors have lots of cases going on, and you're going to make a presentation to say, here are the strengths and weaknesses of the case. And you're going to assist your presentation by some visuals. Now, you want to present a clear and, frankly, fairly objective position about this. Similarly, the context that we have you in with State versus Mitchell from the defense is, if you're on the defense side, you're talking to Joe Mitchell. You're making a presentation to him, to a client, and you're saying, here's the strengths and weaknesses of this case, Joe. You've got to understand that you're risking a capital murder offense here if you're found guilty. One only need to look at the paper today and realize that, you know, in our poisoning cases that jurors, in fact, can be divided about sentencing, and the risks of sentencing can go anywhere from life imprisonment with parole, life imprisonment without parole, and the death penalty. And so obviously Joe's going to need to understand how the case is, how strong the case is, when Joe's trying to figure out what to accept in the way of a plea negotiation. So the visual then becomes a way of talking to the client to help the client understand the strengths and weaknesses of the case. And really recommend that whether it's a corporate client or individual client, that you think, what are my 4 or 5 best exhibits in this case file? And what are the 1 or 2 that are really weak and are hurting me and that are going to be a problem? Whether it's the confession in the note with Joe's handwriting, or whether or not, in fact, it is the timeline that shows that he may have been stalking her that night. So the use of visuals then in a counseling session with a client is a way of teaching, making efficient what it is that you're saying about the case to help the client assess the strengths and weaknesses and make a better call about what the overall objective of the case is. That's our theory here. And so we're asking you to stand up and say, can I make a few slides that would help teach? Now, let me just tell you something about, again, the costs that are involved here. Those of you that are not PowerPoint aficionados, you know, you say, man, that sounds like I get a graphics company, I'm paying $40,000, $50,000 to go ahead and put the graphics together. If I'm in a courtroom setting and I'm using graphics, I might have to pay somebody upwards of $10,000, $15,000 a day to run the visuals for me in a particular situation. Here, we're talking about making a presentation. What's it cost you to make a presentation? Well, there are some kind of givens. Most of you have got laptops already. That's expense that's already done. You'll find out that for PowerPoint and most visual display softwares, you're going to have to take your images and turn them into TIFFs. TIFFs are, you're going to take a picture of it. It's going to have a set of dots. The dots are going to be either small or large, depending upon what the picture taker dot per inch processor is doing and using, but you need a scanner to get it into a system to be able to make some selections. You're going to have to learn how to use the software, and most of you've already know how to use PowerPoint. And so that time might be taken up with no cost to you. It might be that you have an administrative assistant and you give them the PowerPoint for Litigators book and have them work through it, and it costs you $300-400 to help them use it, to learn how to use it. You obtain the software itself. It's usually loaded on most of your laptops, and you learn how to use the software for yourself if you choose to. Now, you then bill the client at a five slide hourly rate. So how much would it cost you to really make 5 slides? Again, in your learning curve, eventually you ought to be able to make 5 slides, frankly, in 15-20 minutes, no more than 30 minutes per slide. But I'll tell you that the time that's spent there on that planning, on distillation, and trying to put into a slide your key arguments and your key facts is certainly something that the client will appreciate and you can bill for. About 30 minutes per slide average in terms of making it, once you've got a pretty good idea of what it is that you want on the slide. So a slide like this, you scan in the picture. You've got to make some boxes. You've got some arrows. You're going to have some animation. And so, scan the photo, bring the photo onto the slide. You draw the boxes. You color the boxes. You type in the labels. You draw the arrows. You add the animations. And for a how-to on this, hit the library. There's a nice book called PowerPoint for Litigators that Nita has out there that allows you and shows you really very much step-by-step ways to be able to create your slides. If you're a complete neophyte, it'll show you everything you need to do in order to do it. There's another version of this now. It's 2002. Most of you have 2003 on your machines, and frankly, it hasn't changed, and the book is still good, is perfectly accurate for your 2003 PowerPoint systems. Now, displaying slides, remember, we got the laptop, you got the projector. A good projector, this cost frankly is quite high now. It's dropped since I've made this slide. I would bet you can get a very good projector with good looms for more like $2,200, $2,500. That's going to be perfectly adequate for you. And they're getting smaller and smaller so that you can carry them around with you. And the connecting cable is $50. A projection screen of some sort. Again, most courtrooms will at least have the projection screen, but if you don't have one, you're going to have to bring it in. And then if you want to import in materials, you may need a wireless remote. Or excuse me, this is a wireless remote. This is what I've got in my hand in order to be able to not be tied to the podium. Of course, if you had an internet connection, you're going to have to find a wireless computer in order to be able to import things in from a remote distance. Okay, so a slide like this with boxes and a picture, about 30 minutes to put together. Now, a couple quick tips before we finish up here for you. As you are creating slides, let me just tell you that over the years, you will probably go through this process unless somebody tells you what I'm telling you. I don't know whether or not you can see this too well. It looks great, I can tell you, on the screen. When you're looking right at the screen, you think, ooh, that's kind of cool. I like the magenta and I like the black on it. The problem is that in even a fairly well-lit room with pretty good looms from the camera, blacks on reds, blacks on blues are often hard to pick up. And so what you're basically looking for is, you're looking for those color combinations that are professional dress color combinations, right? Whites, white shirts, blue suits, right? You're looking for some lighter visible color against a black screen, white on black. And you say, well, what about black on white? Black on white is not bad. In fact, it's pretty good. Some folks complain that black on white, if it's mostly white screen, can give you a headache if you're looking at it. over and over again. Maybe you've noticed that in some of the presentations of faculty members here in Emory Law School, that if they're on black on white, you find yourself getting a little squinty and a little bit of a headache by the time that it's all over. And so be careful about that, especially if your displays are up for long periods of time. Bright colors like these and animations that come in at first have a good appeal to you. You say, oh, I like that change. The problem with the bright colors or the gaudy colors, or frankly the animations, is that in terms of memory, they may distract the viewer, and distract the viewer in such a way that they remember the animation, but they don't remember what the words were. And so we saw the bright colors flash in from the bottom. Note that your opponent will probably say, you see things were flashing in from all over the place. They're pulling things out of the air. And so the animations can enhance your opponent's ability to point out things that are flying and moving. Ed Tufte also tells us that whenever there's any movement, we've got to be careful. The magician uses movement to distract us. And so be careful of your animations and your reveals. And remember that the principle is clarity, credibility, using credible colors, and reveals that frankly are not distracting. So compare. Look at this one. All right? Well, it draws your attention, but do you remember the words animation, pitfalls, if it flies in that way? Or do you only remember the animation? Similarly with sound. Yellow on blue is a pretty sound comparison. You can see it. Its contrast is good. That's a good change up from white on blue. Yellow on blue is a nice substitute. Again, you see how the spinning and twisting words are distracted by the way that they appear. Wipe from the left replicates how we read. And it is, in fact, a good and solid way of revealing. That and an appear is also a good choice for animating points as you reveal the points. Now this is a basic PowerPoint slide that's a bullet list of a set of ideas supposedly related to a heading. The structure of this, its design, is a hope is enhanced by the fact that it's relatively large enough but doesn't fill the screen too much. And that in fact, if what we're doing is just focusing on the amount of text, is there a point where if there's too much text, you bail from reading because there's too much there for you to be able to pick up? And so, whenever you're constructing a slide, less is more. Try to keep the number of words down to their essentials. That otherwise the effectiveness of the slide is overwhelmed by too much information, especially when, in order to get it all in, you lower the height of the letters so that you make your audience not able to read it. When you're thinking about, finally, your audience and you're thinking about your oral presentations, again, it does you no good if what you write up on the board is something that nobody can read. It's not big enough to read. So consider your projection options, how big the screens are, how far away the audience is, and frankly, even consider whether there's glare when you're trying to figure out whether or not you're going to use that particular method of displaying your visuals. Pay attention to those things. Can it be seen? Go back and look from the perspective of the audience to what it is that you're looking at. Can they read it from there? And if they can't, don't just say, well, let me read it to you, because then you might as well not even have the visual there. Then make it big enough so that they can see it. And so you might have some hard boards. You might have some what are called anchor charts that are permanent in a courtroom, that are up there, that stay up there. There are timelines that help us see when things occur. And I would recommend to you that you not just go with whatever the screen is that you have in your PowerPoint system, but that you think, does that system work for this particular point? Now, let me give you a couple quick examples in the State versus Mitchell case file. A PowerPoint slide? Was Joe stalking Leslie is a question that, Joe, they're going to ask you. We know you had a fight the night before. We know that there was a letter that was found, at least it looks like it's in your handwriting, and we may contest that and keep that letter out, but if in fact the judge decides that you write your name Joe very much like that letter was signed, we still can cross-examine about that, but the letter does contain pretty strong language in it, Joe. We know that you showed up at the house on the night of the death, and Joe, we know you followed her to the theater. And the prosecution is going to list these 4 facts, and then we know that you went and picked up your gun, and that the path that you drove your car with a gun with at least 2 bullets in it was right past the front of her boarding house. And remember that at least Miss Thompson's going to say that Leslie yelled at you when she saw you before the shots were fired. Oh no, Joe. These are the facts that the prosecutor is going to lay out that presumably add up to the fact that you were stalking her that night. So this is an example of a basic bullet point list. Now look how visuals also can presumably enhance that, and I want to just show you a couple design features. In a courtroom, for example, if you're a prosecutor, you might shape your PowerPoint points in a bullet list into a set of what looks like little visual cues of arrows that drive. They had a fight, letter to threat, shows up at the house, follows to the theater, and then a box on the bottom that says what the conclusion is, stalking Leslie the night that she died. The little visual cues presumably enhance the advocacy because they have the feeling of driving you in the logic from one point to the next. Another variation on this is that all points lead to Rome, all roads lead to Rome, and so you might arrange it this way, where your points are assisted by arrows to a particular conclusion. Okay? Or you might take what you think is your key exhibit and present the information by way of a timeline. So the similar points are not bullet points, but in fact you take the map and you visually show Thompson residence, Palace Theater, Civil Dollar Bar where he stopped, pounded down at least 4 beers, back around to pick up his gun, and then the path takes him, or certainly can take him, right back past where Leslie was shot. So you see that the presentation of the information then is presumably enhanced, and the power of it is better assessed if you can take it in a visual form and present it in a clear way. And that's just obviously the tip of the iceberg. There are all kinds of things that you can do. You've got pictures to work on. You can import those pictures in. You can annotate those pictures to point out things, where the bullet's found, how the body lies. You can use it in order to be able to not only do bullet points, but set out events in relationship to each other in terms of a timeline. You can take key quotes, display text, and call them out and underline them. Keywords in that letter, for example, can be displayed visually. Just to make a big picture of it is not going to do it. Think about that evidence camera. Draw our attention in to the specific language that you want to present. And that will get you going and get you started, and I hope get you thinking about how it is that you could use visuals to assist in your presentation. And let me add this one word. In terms of preparation as a trial lawyer, preparing your visuals will greatly assist you in refining your theory of the case. It will help you think about sequence, ordering, and focus. And in fact, as a great technique in any case, whether you use the visual or not, take this challenge. Can I put the heart of my case into 1 or 2 slides? And if I can, then I'm going to know that I've got a focus and a tight theory and work that way. One last word of warning. You can get seduced by this stuff, this PowerPoint display, very easily. And when you do, Just like most of the teachers that use PowerPoint, it's one damn PowerPoint slide after another. They lose their effect because you don't let the visual speak. You rush over the top of it, you talk over the top of it. I've done that some here as I've gone through it. Try to limit yourself to no more than 10 slides in an hour-long presentation. See if you can get it down so that you cut out the extras and only use the visuals so that you can maintain their most powerful effect. And as a rule of thumb, 10 slides to an hour, 5 or 6 slides to half an hour is a good rule of thumb. Thank you.